Hello, I call this brief video tutorial, What Does the Contract Say? I'm always asked, should a contract be in writing? Well, an oral contract can be enforceable in court, but if it's in writing, then it's a lot easier to prove or establish its existence and what it says in court. All you have to do is submit the written contract in evidence, and when it comes to a disagreement around an oral contract in court, you're kind of at the mercy of the judge. You can claim you thought the contract meant X, and the other side can claim it meant Y, but ultimately it's the judge that decides, and he can even say, I do not believe one party, but I believe the other party. Now, even when parties put their contracts in writing, there can be disagreements about what a word or a clause means. Now, you can avoid this by defining a particular term in the contract. Let's say, for example, Mr. Smith offers to build a set of cabinets for Mr. Doe for $1,000, and Doe accepts. The next day, Smith shows up to start and says, "Where's the lumber?" Doe says, "You were supposed to supply the lumber." Smith says, "My price was only for the labor, not the materials." Now, there are two approaches that a court can take in terms of interpreting the word build. There's something called a strict or plain meaning approach. This is when you refer to the dictionary meaning of the word. In that case, a judge would look at a dictionary and sees what the word build means and rely on that definition. There's another approach called the liberal approach. This looks to what the parties intended, having regard to various factors, such as the circumstances around the contract, the negotiations, including what was said during the negotiations, the knowledge of the parties, the trade practice in terms of building, and the custom, and any other relevant factors that a court may deem appropriate. Now, sometimes people, after signing a contract, turn around and say, "I did not know the contract said that." Well, since a court case can turn on what the contract stated in writing, often the issue to be determined is whether what the contract stating is binding upon the party challenging that particular term. For example, this is a common occurrence with respect to what we call exemption or waiver of liability clauses. You know quite often that when you sign a contract, one of the parties will be excused from any liability. And that's a traditional method of risk management. If you're a company and you want to enter into contracts, you would have a clause saying that the party signing the contract with you cannot hold you liable. Okay? Now, a court will scrutinize the facts of a case very carefully, and if the company knew the client did not read the contract, thereby meaning the signature really did not represent the true consent or the true intention of the person who signed the contract, the exemption clause could be deemed invalid. This is what occurred in the Tilden Rent-A-Car versus Clendening case, a 1978 decision of the Ontario Court of Appeal. Mr. Clendening rented a car from Tilden at the Vancouver airport. At the time of entering the contract, he was asked if he wanted additional insurance, which involved a higher fee, but did not provide full non-deductible coverage. He thought that if he took it, this would protect him if the car was damaged, and he agreed. Now, like many of us, he was in a hurry, and he signed the long agreement without reading it. And in the back of the agreement, in small type, it said that insurance was inoperative if the driver drank any alcohol. Now, Clendening was unaware of the clause. He didn't see it. He drove into a pole after having some alcohol, and Tilden sued to recover the cost of the car. Now, the legal question in the case was, can Clendening rely on the clause providing him with full non-deductible coverage, or is that clause inoperative because he consumed some alcohol? A condition in the contract which he knew nothing about. The Ontario Court of Appeal decided the case and said that Clendening's signature on the contract was not a true assent to the terms of the contract, and Tilden could not rely on the exemption clause denying insurance coverage. It was Tilden's responsibility to show that it took reasonable measures to draw these terms to Clendening's attention. So how do car companies deal with this situation, and how do they implement this decision? Well, as you know, if you rented a car recently, what they do is they briefly explain the optional clauses, and they ask you to initial, okay, that part of the document indicating whether or not you accept or reject those clauses, for example, insurance coverage. One thing you should note is that courts may be less sympathetic to a non-consumer situation. For example, a contract dispute between two commercial enterprises. In such a case, a court may expect both parties to understand the contract, as they are probably represented by legal counsel, and time is not of the essence. There's no rush, like the type of rush that Mr. Clendening was in at the airport. Okay? Now, a signature alone may be deemed enough to indicate true and full consent to all terms in a situation when you're dealing with sophisticated bargaining parties like two corporations represented by lawyers. Thank you very much.